Hello everyone. This presentation today will be discussing the concept of possession in property law. This concept is important for you as owners and managers of Airbnb properties or as customers to be aware of, as you should be familiar with legal rights and obligations associated with these kind of arrangements that you're involved in. And this talk will focus particularly on rights to possession of goods that are found in the spaces that are rented under these arrangements, as well as highlight the legal uncertainty surrounding this. We will have to hit some case law, but what sort of lawyer would I be if I didn't bore you for at least a few minutes? So today I will be discussing with you a case from 1998 in which on one side we have Mrs. Flack, who was the tenant of a residential property which she had given her son access to by giving him a key to the house. On the other side are the police officers, who had suspected her son may have been involved with drug-related offences and therefore as part of this investigation executed a search warrant of the property. During the search, the police officers found a locked briefcase in a cupboard in the house containing $433,000, which they took and withheld for the purposes of the investigation. Mrs. Flack denied being the owner of the briefcase and having any knowledge of the briefcase or who the true owner was. Obviously, the son would not come forward and claim ownership of the money as this would then be evidence of his illicit business dealings, and therefore the money went unclaimed. After the investigation was completed, no prosecutions were made against the son, but the police continued to hold the briefcase and money in case they needed it as evidence. Years after the investigation, when it was no longer required for that purpose, the police still refused to return the briefcase and upon Mrs. Flack's request, and so she brought proceedings against the National Crime Authority to have it returned. This case was relatively clear-cut, but if this was an Airbnb situation, it would have been a lot less certain. Firstly, you should know about what possession actually is from a legal sense. Possession stems from custody, which is having physical control of something. Possession extends this by also requiring a mental element of holding this thing for your own use. I will use a puppy for my analogy here, as everyone loves puppies. Consider a puppy and the puppy's mother, who is bringing a bone to the puppy. In this sense, the mother is transporting the bone to the puppy, so she controls it, but she does not plan to use it for her own benefit. Therefore, she is the custodian of the bone. Once she passes the bone to the puppy, and the puppy begins to chew on the bone, the puppy is now in physical control, and can be considered to have possession of the bone, as he is also using the bone for his own purposes. He will likely guard the bone or hide it in his kennel, as he clearly intends to exclude other puppies from chewing on or playing with his bone without his permission. It is important to note that possession only involves physical, tangible things, such as the puppy's bone, and not ideas or information. I'm sorry to disappoint you, but I cannot stretch my puppy analogy to this detail, as puppies are incapable of abstract thought. Once possession is established, the law will give the puppy who has possession of the bone the right to have the bone returned if another puppy tried to interfere with his right to the bone, such as to chew it himself or bury it in the yard where the first pup cannot find it, and this right is applied against all other puppies except the true owner of the bone. Please keep in mind this does not apply to actual puppies, it is human law. This is straightforward enough if the puppy stumbles upon the bone in the street. The puppy has the right to retain the bone against all other puppies except the one who actually owned the bone in the first place. However, if the puppy stumbled upon the bone in another puppy's backyard, it's not so clear-cut which pup will have the right to possession of the bone. Sorry to drop some case law on you, but now I must talk about that case I introduced you in the introduction, which is the case Chairman, National Crime Authority versus Flack, which tells us that in the case of the puppies, the puppy who lived in the backyard where the bone was found would have a better right to possess the bone than the puppy who found it. The question for the courts to consider in determining whether the briefcase and money should be returned to Mrs. Flack, or whether she, as sole occupier of the residential premises, had a right to possession of the briefcase and money which she does not own. If she does, then she has a superior right to the briefcase and the police officers, and is able to sue them for interfering with this right by not returning the briefcase to her. The single judge of the federal court came to a conclusion in favour of Mrs. Flack. The judge relied on the principle that the rights of an occupier of premises where goods are found will be superior to the rights of the finder, provided it can be shown that the occupier had the required intention to exercise control over their premises, and then hence all goods on those premises. This intention is presumed to be enough where the premises are of a private residence, and hence which the owner or occupier has exclusive possession. In the judge's view, Mrs. Flack was the sole occupant of a private residence, and therefore she did have the necessary intention. Other key points this case tells us is that where goods are found in a private residence, the occupier still has the superior right to possession of the goods than the finder, even if the occupier has no knowledge of the existence of the goods. This right is also not affected by the occupier's lack of acceptance of control over the goods, or the fact the occupier is not the true owner and does not know who the owner is, or the fact that the goods were not lost or mislaid. This means the fact that Mrs. Flack was not the owner of the briefcase, was unaware of its existence in her house, and the fact that it was most likely deliberately placed in the cupboard by the actual owner makes no difference to her rights to possession. The National Crime Authority appealed to the full federal court, but the principles and decision of the judge of the federal court were reaffirmed by two of the full federal court judges. The decision was not unanimous, however, as the final judge did not agree that Mrs. Flack had a right to possession. The judge believed that the presumption that she has possession of the briefcase because of her control of the premises as householder, demonstrating an intention on her part to exercise control, is rebutted by the fact that it would impose on Mrs. Flack possession of unwanted goods, that at the time of the briefcase being removed, she made clear that she would never have voluntarily have taken into her custody or her control. As a result, the judge believed the possession of the briefcase did not pass from the person who put the briefcase in the house to Mrs. Flack, and hence they never came within the protection of her house. So, what about if Mrs. Flack was not sole tenant of a private residence? If it was a public premise, the presumption is not there, and generally speaking, the finder would have a better right to possess the found object, as the owner of a public place is not assumed to have the intent to control everything on those premises. But how would things have turned out differently for Mrs. Flack if the nature of occupancy of the private residence was a bit different? Say if Mrs. Flack had been occupying the premises as an Airbnb guest instead of as a tenant renting the property. Based on the principles of the original Flack's case, it would seem logical that it is less likely the court would have found in her favour, as the decision was based on her position as sole tenant occupying an ordinary private residential house, giving her the right to exclude all others from the house, including the landlord, and hence all the goods within it. An Airbnb guest, on the other hand, may not be seen this way, and could be viewed as more having a licence to occupy the premises, in a similar way to the rights of Mrs. Flack's children, who she had given keys to the house to, making them licensees of those parts of the house which they were permitted to access or occupy. However, when the nature of occupancy of Airbnb guests compared to that of occupancy as a tenant was considered in a recent Victorian case, the court decided that in that case the Airbnb guests did have exclusive possession over the property, which shows us that it is possible for the courts to see the occupancy in the same way as a lease, not a licence granted by the owner. This suggests that this is still a bit of an unclear part of the law. Hopefully some future case specifically considering Airbnb occupancy in the context we looked at today of found goods on premises, or a Queensland court's decision, or some future legislative reform can shed a bit more light on the uncertainty of possession in this context. Thanks for making it through the entire presentation today. I hope you learnt a thing or two.